Right, in this video I want to talk about the law and self-defense, what you're actually legally allowed to do to defend yourself, and what constitutes crossing the line. Now, I will be talking about the law as it applies to England and Wales in the United Kingdom. If you live somewhere else, I would suggest that you check the law in your own country or your own state. It'll probably be something similar, but you will have to check it. You should really check it in your own country or state. Okay. First thing I want to mention is sometimes it's said, like, if you do martial arts and you're in a self-defense situation, you have to warn the other person that you do martial arts. Well, that is false. You don't have to warn them. Okay. In fact, in many respects, if somebody kind of threatens you and say, back off, I do martial arts, I do karate, I do whatever, that could be taken as a counter challenge and you could make the whole situation worse, okay, if they see it as a counter challenge. So no, you are not required to tell the person that you do martial arts. In fact, probably negative if you do so. Another question which might be a little bit surprising is, if you do have to defend yourself, are you actually required to prove that it was self-defense? Now, the answer to this one actually surprised me, to be honest. The answer is no. In a court of law, if you are claiming self-defense, then it's up to the prosecution to prove that it wasn't self-defense, not up to you to prove that it was. Now, but having said that, you've got to be careful, because first of all, you have to, depending on what the situation is, depending on what witnesses or CCTV cameras were around at the time, the other sides may have a good case, especially if the other guys come away injured. The other thing you've got to consider is that in a criminal prosecutions, then yes, they have to prove that it wasn't self-defense. However, should the other guy take you to court in a civil court, in a civil suit, then that isn't done by, that works in a different way. In a criminal court, you have to prove beyond a reasonable doubt that the person is guilty. In a civil court, then it's just a balance of, 50-50. If it's 51% to one, 49% to the other, then the 51% wins. It's just a balance of evidence, so it's not the same legal requirement if the person takes you to a civil hearing. Okay, so that's always worth bearing in mind. Now, what actually constitutes self-defense, acting in self-defense? Now, basically, if somebody insults you, or they insult your wife, they insult your kids, and you step outside to sort it out, then you're breaking the law. Okay? Fighting is illegal. Unless, of course, it's a sport fight, that's different. But fighting somebody is illegal no matter how much they provoke you or how much you may feel provoked. The minute you step outside to sort it out, or equivalent, you're breaking the law as well as them. Now, if, however, somebody picks a fight with you and you say, look, I'm not interested, mate, I don't want to fight. And they say, well, I don't care whether you want to fight or not. I'm going to beat the crap out of you. If you don't want to fight back, you can stand there and take it. That's fine. Now, if the altercation is forced upon you, we're no longer talking about a fight, we're talking about self-protection. And the main difference between the two is it consensual or not? If you are consenting to the fight, then it's not legal. If you are not consenting to it, but it's being forced upon you anyway, under those circumstances, then you are allowed to defend yourself. You are also allowed to hit first. If you honestly and sincerely believe that you are in danger, you are allowed to hit first. Now, this surprises some people because they always think in terms of self-defense, the other person hitting you first. But if you've got somebody kind of right up in your face and they're frothing at the mouth, snarling, you know, really being aggressive, and they're threatening you and they're right up there, all it takes is, and it's over and done with. It's finished. Okay, quick headbutt and it's over and done with. Now, there are tactics, fence tactics, to keep the person at bay, to stop them getting that close to you. So that aside, okay, if there's general guidelines which we use, as a rule of thumb, if the person is being aggressive and they're threatening you and they are coming within your personal space, then you pretty much have the right to feel that you're in imminent danger and the person is likely to attack you. Under those circumstances, you are actually allowed to hit first. Okay? Now, following on from this is there's a question of, are you allowed to use lawful force? Now, lawful force, if you are defending yourself from an attacker who is going to assault you, regardless of whether you consent to take part of it or not, then you are allowed to use lawful force to protect yourself. If the person is using force against you, regardless of your consent, that force that they are using is not lawful. You are allowed to use force to protect yourself. You are allowed to use force to protect your loved ones. You are allowed to use force to protect your property. And you are also allowed to use force to prevent a crime being committed if you happen to be around at the time. You are also allowed to help out a police officer if you see them about their duty being attacked and they need assistance. You are allowed to step in and help them. But you are not allowed to use force because someone has insulted you, someone has provoked you, someone's insulted your missus. That's one of the hardest ones for men. If someone's attacked, insults your missus, it's very hard for a man to kind of walk away from that. But legally, we have to. Okay? Another consideration is, bearing in mind we are not allowed to consent to a fight. If someone is starting something with us, if we are able to remove ourselves from the situation, then we are expected to do so. Okay? We cannot, if we're in a pub, for example, and someone starts picking a fight on us, if we are able to walk out of that pub and go somewhere else, then we cannot claim self-defense if something kicks off. We could have removed ourselves from the situation and the situation would not have occurred. So we are actually required to remove ourselves if we are physically able to. Yep. Then there's a question of minimum force. Now, that opens up an entire can of worms. So if, for example, I'm outside and someone who is maybe a bit smaller than me, they're drunk, they can't fight properly because they're all uncoordinated and all over the place. If that person attacks me, minimum force would be to restrain that person, okay? Because I'm bigger than them, I'm more capable than they are, I've still got my wits about me, they can't coordinate. I should be able to restrain that person relatively easy, okay? I use the term relatively. If, on the other hand, that same drunken person attacked a 70-year-old woman, now that 70-year-old woman would not be able to restrain the man. So if there happened to be a weapon nearby, so we say a brick, and she picked it up and hit the guy, then in that case, that would be minimum force for her. Because if she just hits the guy with her fist, it's likely to not hurt him very much. Then he's going to be, not only is he being aggressive, but he's going to be very pissed off that this 70-year-old woman has hit him. So he's likely to get even more aggressive and he's likely to hurt her even more. So she would have to be able to put him down and incapacitate him straight away. And if that means using a weapon, then so be it. Which covers the other question of, does the response have to be appropriate to the attack? Now, again, if some young guy is attacking a 70-year-old woman and she responds in kind, then the chances are he's going to get angry and attack her further. So her response doesn't have to be appropriate. She might have to hit him a lot harder in order to ensure that he leaves her alone. If a guy my size or smaller than me punches me and I punch him back to show that, I'll give as good as I get, he may think twice about it and walk away. He may not think twice about it if it's a much older person or a much smaller person. So the appropriate force may be different in each case. Okay? Okay. Now, key phrase to remember is, what do you honestly and instinctively feel is required at the time to stop the person attacking you? Now, as we've already discussed, if a guy my size is attacking me, I might just be able to hit him and that might dissuade him from attacking me. If it's someone much smaller, if someone's attacking someone who's much smaller, much weaker, maybe a man attacking a woman, they might instinctively and honestly feel, well, if I just hit him back, he's only going to come back and hurt me even more. So if they honestly and instinctively feel that they have to use a weapon, then so be it. That is okay under law. Of course, you have to make that case. You have to be able to kind of, give some kind of credible case to the courtroom, or potentially. But if you honestly and instinctively feel that's what you need to do, then that is right under the circumstances. Now, the law will make allowances that if you are in fear for your safety or possibly fear for your life, the adrenaline's kicked in, you don't think quite as well as you otherwise would, then under the effects of adrenaline, you might make mistakes. And the law will accept that you might make mistakes under the effects of adrenaline. What the law will not make allowances for is if you're high on drugs, or if you're drunk, you've been drinking a lot, consumed too much, you're drunk, that is what they call voluntary intoxication. Now, if you have put yourself in that position in a mind-altered state with alcohol or drugs, and you make a mistake, that will not be tolerated by the law because you put yourself into that state in the first place where you made the mistake. So if it's effects of adrenaline, then yes, that can be used as a legal defense. If it's effects of alcohol or drugs, then no, that is not a legal defense if you make a mistake under that circumstances. Now, another thing to consider is, shall we say someone's attacking you, you push them away, they trip over and maybe they crack their head open against the pavement and they're dead. Where do you stand legally there? Well, again, we go back to, what did you honestly and sincerely believe or honestly and instinctively believe that you had to do to defend yourself? And if you acted reasonably, if someone's throwing punches at you and you push them away, that is quite a reasonable thing to do. If they trip over and then crack their head open on the pavement, well, that's a different matter. The consequences are not necessarily taken into consideration if you acted reasonably under the circumstances. So again, you may have to argue your case, whether you was reasonable or not, but that is a valid legal defense. Now, another thing which may come up is, am I allowed to use weapons? Now, again, you have to check the law in your own country, your own state. In America, you're allowed to carry weapons. In the United Kingdom, we are not allowed to carry weapons, even for self-defense. So, should I be involved in an altercation and I do use a weapon, then again, the first question is, was it reasonable for me to do so? If someone is threatening me with a knife and I pick up a baseball bat or a brick and I hit them with that, I'll say that's quite reasonable for me to do so. And what I instinctively and honestly felt I needed to do to protect myself from somebody with a knife. And I don't think most most courts in the land would argue with that. If, however, I had taken out a weapon with me, like I'd carried a knife with me, or taken a gun out with me, somebody starts on me, they pick the fight, they cause it, and I use my weapon against them. Let's say I've got a gun and I shoot them. Well, from a self-defense perspective, then yes, I may have acted appropriately. The guy was attacking me with a knife, and it was appropriate for me to draw my weapon and use it in self-defense. However, I've crossed the boundaries. There's another law saying you don't carry offensive weapons, and I have crossed that boundary of carrying an offensive weapon. So I may get charged for that, for carrying the offensive weapon, but I shouldn't be charged with using it in a reasonable self-defense matter. So when it comes to self-defense and law, there is a bit of a can of worms. I hope that helps. But like I say, check the law in your own country or your own state. If you live in the UK, there is a book you might be interested in. It's called UK Self-Defense Law by Lee Sims. Lee Sims is a 4th dan black belt at karate, and he's also studied law. Part of his law study was the law of self-defense. And I'm going to be honest, a lot of the information I got for this video was from Lee Sims. So I would highly recommend his book if you're really seriously interested in this subject. You can get it on Amazon. I'll leave a link in the description below. But yeah, it's worth having a look.